Sometimes workplace disputes raise questions under both a CBA and the NLRA. Generally, questions regarding how to interpret the CBA are for an arbitrator to resolve, at least if the dispute is arbitrable. The board and the courts are responsible for interpreting and enforcing the NLRA, but sometimes these respective responsibilities overlap, as in the next examples. A union represented a bargaining unit consisting of an employer's production employees. The union filed a grievance claiming that engineering employees were doing work that should have been assigned to production employees. The engineering employees were in a separate bargaining unit represented by a different union. The employer refused to arbitrate the grievance, asserting that the dispute was a jurisdictional controversy that had to be resolved by the board under the NLRA. The union sued to compel arbitration. The Supreme Court ruled that the arbitrator could decide the grievance, even though the dispute might raise an issue the board would ordinarily resolve. Here's another example. An employer unilaterally implemented a new merit wage increase for employees who met certain production targets. The union filed a ULP charge with the board, alleging that the employer had failed to bargain over the pay increase. The Supreme Court held that the board could properly adjudicate the ULP charge, even though doing so would require the board to determine whether the CBA's wage provisions permitted the change. If a dispute involves both a contract grievance and a ULP charge, the board will sometimes postpone the case until a pending arbitration is resolved, or defer to the result of a finished arbitration.